All right, so
It
we
says
are
live.
live today with.
I have to check to see if I am in fact alive, but there is a little thing in the screen that says live.
Yes, we're good. So this is the music publishing podcast with Marc Ostrow today. We're going to talk about some copyright and fair use stuff. Let me move my microphone. Um, so, Mark, tell us a little bit about yourself, what you do, and all that stuff.
Well, I am a copyright and entertainment lawyer, focusing largely in the music biz. I've been doing this for over 20 years. I am currently in private solo practice, although I am of counsel to a boutique firm that does all sorts of other stuff, including corporate and litigation and other IP. So
Nice.
I have that affiliation so I can better able help uh, music and other creative artists with whatever they need help with.
Mm-hmm.
And before that, I was the head of the New York office of Boozy and Hawks. Um, and I had been hired at Boozy by my dear friend Jenny Billfield, who at the time was the head of the New York office, and she hired me to run the business affairs department. And when she left to go to Stanford Live, they promoted me to her chair, but didn't give me a new me in business affairs, which was kind of fun for a while. And before Boozy, I was in the legal department of BMI for about 5 years.
Mm,
And before that, I was the chief cook and bottle washer and general counsel of a boutique jazz publishing firm called Second Floor Music.
nice.
And before that, I was in private practice in big and mid-sized law firms. In addition to all that, music is near and dear to me because I have studied music from the time I was a kid and studied music and English in college. And while our dear friend Frank O'Terry would refer to me as a composer, I consider myself more a songwriter
Mm-hmm.
and occasionally do gigs at Cornelia Street Cafe of my own original songs. So
Nice.
I like to think that I can uh, have the perspective of both a lawyer and a creator, and I've certainly represented users and licensees as well.
Mm-hmm.
So that's kind of my background.
Nice, nice. I had forgotten until I saw you a couple of weeks ago that you were with Boozy. I totally that had slipped my mind. I was like, oh yeah, that's right.
Oh yeah, I used to run the New York office once upon a time.
What? Eh. So today, let's talk a little bit about copyright things. I know when we spoke a few weeks ago, you said maybe deal with some misconceptions about that and about fair use. Like that might be a thing that we can touch on. What I guess let's start with what are some of the basics of copyright that you think that composers and I know that that's a broad thing to say, but what
Well,
are some of the basics that we should know?
I do a fair amount of these copyright 101 lectures, and
Mm-hmm.
the last one I did was earlier this year for the NYU Composers Forum. I've done them for composers forums at Curtis and at Juilliard. So I'm happy to kind of give a little bit of the basics with an eye towards what specifically composers need to know about
Mm-hmm.
copyright. But this is general copyright principles. For example, and when I talk, especially since I'm having a conversation with you,
Mm-hmm.
I like to use a lot of Socratic method when I lecture. Oh, I
Mm-hmm.
forgot to mention I teach music business courses at
Yes.
Westminster College of the Arts at Rider University, and I just finished my semester. So, anyway, I do a lot of Socratic method because I get tired of hearing myself just drone on. So, the first thing I usually start with is where does copyright come from? Does it come from, like manna from heaven? Did God give it to Moses on Mount Sinai with, a set of tablets that were dropped, as in History of the World Part One? Is that one of the other 15 commandments? So, you get to be my pupil today, if that's okay with you.
Hooray!
Okay, so Dennis, where does copyright law come from?
Oh well, it's um the history of, or just that it's from the I
Well, is copyright? Does every state have a copyright law, or is it federal law?
oh well, there's federal law, and then there's the international sort of, well, not necessarily law, but we at least will try to adhere to other.
We try to adhere to the Berne Convention, and we
Hmm.
may get into a little bit of that later. But copyright law is a creature of federal statute.
Hmm.
And so, where do federal statutes come from?
They come from the legislature.
And
they're law
what do we call the federal legislature here in the
from
United States?
Congress.
From Congress, that organization that
That
does a
thing.
whole lot of nothing,
Hmm.
um, and is so very popular today. So, where does Congress get authorization to enact copyright laws?
From the people.
And by way of what?
Uh, uh, Elections.
Well,
And
no.
well, by way of the Constitution.
Yes, exactly. When I was teaching a couple of semesters ago, I said, so, where does Congress get authority? And the students were like, the Declaration of Independence, and I said, no, the
Nope,
other one.
the other one.
And, and they said, oh, the Constitution. Yes, Article 1, Section 8, Clause 8, for people who like to look this stuff up,
Hmm.
is the copyright clause, sometimes referred to patent clause, because it authorizes Congress to enact both patent and copyright laws.
Hmm.
And copyright has been so important to this nation, that when the first Copyright Act was enacted?
I've forgotten.
In the very first Congress of 1790.
Mm.
So one of the first things the very first Congress did was to enact copyright law.
Hmm.
So the copyright law has gone through various iterations since 1790. It's been amended a number of times.
Hmm.
The most recent overhaul of the Copyright Act of 1976, which went
Hmm.
into effect January 1, 1978. And before that was the Copyright Act of 1909. And the one before that, I don't even remember when it was. So, for those of us who are dealing with copyrights that are that are still in effect, that for works that have not yet gone into the public domain, they were either created while the Copyright Act of 1909 was in existence,
Hmm.
or the Copyright Act of 1976.
Hmm.
And basically, even for older copyrights, the current Copyright Act basically says, Copyright Act of 1909 is superseded, and there's
Hmm.
provisions that apply for older copyrights, usually for duration of copyright and for termination. So
Hmm.
we know where copyright comes from.
Hmm.
When do you get a copyright?
As soon as the idea is fixed onto, so if once you write it down in some form, or
Well,
record it
the
in some
term of art is as soon as you are absolutely correct. It is as soon as the expression of the idea
form. Hmm.
is fixed in a tangible medium.
Hmm.
And so that means as soon as you put the pen down, or as soon as you hit save, or as soon as you hit print, um, any tangible medium, so even saving it to a hard drive or a thumb drive, as soon as it's fixed in a tangible medium,
Hmm.
you have a copyright.
Hmm.
So we'll get to in a minute as to why sometimes people mail copies of things to themselves, and
Hmm.
why, and
Yeah, I
what the
want to talk about
difference
that.
and what the difference is between having a copyright and having a copyright registration.
Yes.
Two different things.
Hmm.
So you have a copyright, and you have most, but not all, of the copyright rights available under this Copyright Act
Hmm.
uh, as soon as you put the pen down.
Hmm.
But notice that a half a minute ago, you had said as soon as the idea is fixed, and I amplified that slightly by saying as soon as the
Expression.
expression
Yes.
of the idea is fixed. And the reason for that, if you allow me to take a sip of my adult beverage.
Yes. Cheers, by the way.
Cheers. See, sound effects. I have a glass of water, so that's like we're clinking.
Nice.
Nice touch, huh? Um, so anyway, copyright, you can't get a copyright in an idea. So you can only get a copyright in the expression of
Mhm.
an idea. So let's give a few specific examples to address the idea expression dichotomy, as we attorney copyright lawyers like to say.
Mhm.
Um, and the idea expression dichotomy is actually in the copyright statute. There's a provision that says ideas are not copyrightable, only
Mhm.
expression. Um, and so basically, let's take the idea of a drama about star-crossed lovers.
Mhm.
Okay, well, that goes all the way back to Ovid and Pyramus and Thisbe.
Mhm.
And then you can fast forward a few hundred years to Romeo and Juliet.
Mhm.
And then you can fast forward a couple of hundred years to Abe's Irish Rose,
Mhm.
which that, not Romeo and Juliet directly, was the basis for
Oh,
your
I don't.
one of our favorite musicals by one of our favorite composers,
Oh, West Side Story.
West Side Story, correct. So all of those are different expressions of the idea of star-crossed lovers.
Mhm.
For musicians and composers, a more practical aspect is you cannot copyright in addition to ideas, you can't copyright titles. So song
Mhm.
titles are not copyrightable. You can't
Mhm.
copyright short phrases.
Mhm.
So, you know, you can't copyright a sentence per se, although you can certainly get a trademark and a slogan that's a different form of intellectual property, which,
Mhm.
if we want to go off on a tangent and discuss trademark law, we can do that. So the grammatical tools of language are generally not copyrightable. So the same thing goes for music. For
Mhm.
example, chord changes, chord progressions are
Mhm.
not generally copyrightable unless
Mhm.
they're completely married to the orchestration
Mhm.
of a piece. You can't, Wagner could not have gotten the copyright in the Tristan chord.
Yeah.
Okay, nobody, imagine if you could copyright the Circle of Fifths, we'd still be paying royalties to Vivaldi.
Yeah.
Imagine you could get a copyright in the Falling Thirds chord progression.
Mhm.
Every 1950s doo-wop tune would,
Yeah.
so that's the difference between expression and and the underlying idea. Chord
Mhm.
changes, um, standard uh, cadences like a simple 5/1 cadence or a 4/1 plagal cadence. You can't copyright that.
Yeah.
So it's the expression that you can get a copyright in. And again, as soon as you put the pen down, hit save, you got it.
Mhm.
So why is there this thing called the poor man's copyright, um, where somebody would take a manuscript or burn a CD
Mhm.
and mail it to themselves and not open the envelope? Um, what, if anything, does that do? Um, the only thing that it really does is that it provides some evidence of when the work was written and
Mhm.
when it was fixed in tangible medium.
Mhm.
Now, let's talk about registration.
Mhm.
Back in the old days, um, before, under the 1909 Act, registration and all sorts of formalities were mandatory.
Mhm.
We joined the Berne Convention, which has been around since I think 1879, but somewhere in the 19th century.
Mhm.
And even though the United States is the largest producer of uh, creative copyrighted content in
Mhm.
the world, if you think about music and film and all sorts of visual arts, we didn't join the Berne Convention until 1989.
Mhm.
And so we had to adjust the Copyright Act somewhat. And in fact, the 1976 Act was created with an eye that the United States would be joining the
Mhm.
Berne Convention at
Mhm.
some time in the not too distant future.
Nice.
So that's why registration is permissible it is advisable, but it is no longer mandatory.
Hmm.
So that's why you get a copyright as soon as it's fixed in a tangible medium to
Hmm.
comply with Byrne. That's done away with a lot of registration and formalities. And you don't even have to put a copyright notice, the little C in the circle, you know,
Hmm.
copyright 2016 Dennis Dubensky.
Hmm.
Um, it's always advisable to do that. You put people on notice that this
Yeah,
is your work and you're claiming
exactly.
copyright ownership of it, but you don't have to do
Hmm.
that.
But that was a requirement at some point that you had to put that, and
Yeah,
maybe, and wasn't it that like all you had to do was put that on there, and that was people because sort
yeah,
of are on notice, or did it require the
you
registration too?
had to put people on notice
Hmm.
under the old act. But what we have now is there, since registration is not mandatory, there are certain statutory incentives that make it really advisable for
Yeah.
people to register their works with the Copyright
Hmm.
Office. For example, you cannot file a lawsuit. If somebody rips you off,
Hmm.
you cannot file a copyright infringement lawsuit in federal court. And because the Copyright Act is federal law, and the Copyright Act states that federal courts have exclusive jurisdiction, you
Hmm.
have to file in federal court. You can't go to state court.
Hmm.
Other federal claims, like employment discrimination, you can file either in federal court or in state court.
Mm.
Copyright, you have to go to the feds.
Yeah.
But the Copyright Act states that you can't file a copyright claim, file an infringement case, um, unless you have a valid registration.
Hmm.
So there's a pretty good incentive for you to
Yeah.
file a registration.
Exactly.
There's another incentive. Uh, Again, filing with the Copyright Office is kind of like filing a deed to
Hmm.
a piece of property,
Hmm.
or filing an ownership certificate for a car, or
Hmm.
that sort of thing, your UCC filings. Filing with the Copyright Office, that, more than sending a copy to yourself in a sealed envelope that you don't open,
Hmm.
that gives you the point in time
Yes.
under federal law when you the work is deemed to be registered.
Hmm.
And when you file an application, uh, the date of creation isn't necessarily the time that you're filing the certificate,
Hmm.
although I certainly would advise that you do a registration within a relatively short period
Hmm.
of the time when you actually create the work. Um, but you state when the work was created.
Hmm.
And if you file your registration within a certain period of time when after you create the work, there's a presumption that all of the statements in the copyright application, which then get transferred to the copyright certificate of registration,
Hmm.
are what we call prima facie evidence of the veracity of those statements,
Hmm.
meaning that it creates, as we say in the legal biz, a rebuttable presumption,
Hmm.
meaning that in any litigation, it would be the facts are basically taken as true unless the other side provides evidence to rebut them.
Hmm.
So that's another pretty good incentive. Then there are two different kinds of damages
Hmm. Yes.
for copyright infringement. There's
Yeah.
actual damages, which is, as you might expect, the infringer's profits
Hmm.
and or your lost revenue.
Hmm.
Sometimes with music, for example, the actual damages are far less than what it would cost to prosecute a lawsuit.
Hmm.
And because uh, Congress wanted to create an incentive for copyright owners to be able to enforce their rights, because
Hmm.
after all, if you have a right without a viable remedy, you don't have much of a right.
Exactly.
Um, there's this thing called statutory damages,
Hmm.
and statutory damages run between in the discretion of the trier of fact, which can be a judge or a jury,
Mm-hmm.
um, run between $750 per infringement
Mm-hmm.
up to $30,000 per infringement.
Mm-hmm.
And if the infringement is deemed to be willful,
Mm-hmm.
which is in the damages statute but not defined in the Copyright Act,
Mm-hmm.
but for our purposes, if it's with knowledge and intent and really, really bad,
Mm-hmm.
like all the pirate sites that promote
Yes.
infringement,
Mm-hmm.
um, willful infringement can be up to $150,000
Wow.
per, per claim.
Nice.
However, going back to incentives for registration,
Mm-hmm.
you cannot get statutory damages. You are limited to actual damages and other relief, such as injunctive relief,
Mm-hmm.
unless you obtain a copyright registration prior to the infringement taking place.
Yes.
Now, how do you know when infringement takes place? Unless you've got a crystal ball,
Mm-hmm.
you don't.
You don't.
So the incentive is again to register at the time or soon thereafter when
Mm-hmm.
you create the work because you
Mm-hmm.
don't know when you're going to be infringed.
Yep.
So the sooner you register, the more likely you're going to sweep in any potential infringement claims.
Mm-hmm.
So that is the difference between having a copyright where, again, you know, with without copyright registration in the Copyright Office, you do have a certain amount of rights,
Mm-hmm.
and people have to get your permission to use the work unless it's fair use
Mm-hmm.
or unless some sort of compulsory license applies.
Mm-hmm.
But it's awfully hard to demonstrate, uh, if somebody claims, well, I wrote this song, and you say, no, I wrote it first,
Mm-hmm.
without a copyright registration, it's sometimes difficult to prove
Mm-hmm.
timeline,
Yeah.
number one, and number two, you don't get statutory damages
Exactly.
if you don't register prior to the infringement taking place. So does that make is that all clear? Any follow up questions on those niceties of
Yeah.
copyright
That. I heard recently, and I sort of like shook my head a little bit. There was a talk I went to where some people said, "Oh yeah, just they talked about like just do the poor man's copyright, stick it in an envelope, mail it to yourself." And I was like, oh, like if you're worried about people stealing your work,
if the
then
work has any value.
yeah,
And again, sometimes if you write a song and it's not recorded, it's not being publicly performed, it's not a
hmm
commissioned work that's going to have a premiere,
hmm
at that present time, it doesn't have a whole heck of a lot of value
yeah,
until the work is being quote unquote exploited,
hmm
as we say in the legal biz. Um, but filing a copyright registration, as opposed to filing a trademark registration or obtaining a patent, is
hmm
relatively simple and relatively cheap.
yeah.
It's what is it? I think it's 30 or 35
I think
bucks,
$35.
$35 to do it online,
Hmm
and subject to certain requirements that all the copyright claimants uh, are the same, and a couple other restrictions. You
hmm
can um, file a registration for multiple works under
hmm
one registration.
Yes.
So it's easy, it's inexpensive.
hmm
If you have a bunch of quote unquote unpublished songs or compositions, you can do what we used to call a folio registration. And for one
hmm
registration fee, you can register all those titles. So there's no reason to do the poor man's copyright.
hmm
Just go online at copyright.gov and do a copyright registration.
hmm
For other forms of intellectual property like trademark and especially patent, you really need a lawyer to
hmm
do this. For most simple copyright registrations, where it's, you know, a, for example, a musical work, whether it's a song or an opera, and there's, one or maybe two, maybe three creators,
hmm
um, it's you don't need a lawyer to do the copyright
Yeah.
registration.
Yeah, I've done a few, a few registrations myself. I'm actually a little bit behind on that, and I need to get my house in order. But yeah, it's a very simple form. I filled out my first copyright form. The very first piece I wrote, I was like, I'm going to copyright it, and so I did it when I was 14, and it was
Right, and you
super
filled out
easy.
the by hand the old PA form,
Yeah,
right?
yeah.
Mailed it in.
Mm-hmm.
'Cause I don't think you could do the online
No,
registration.
no, not back then. But yeah,
So
it is a very easy very easy process. Um, the folio registration is something that I've been thinking of doing to get kind of to get myself up to speed with sort of the sing when it's just me as the
mhm.
composer. One question I have for you about that sort of an idea is, um, let's say someone, we'll just use me as an example. I have several song cycles with texts by living poets,
Mhm.
and so all of, they own the copyrights for those. um, are those able to be registered as a folio, or do you have to do separate registrations for each because there
If
is?
the permission that you have been granted
Mhm,
by the poets, and since they're living, their copyrights are in effect.
mhm,
If you've gotten permission where where the permission is you pay whatever you pay, whether it's a flat fee
mhm,
or a royalty,
mhm,
um, or a combination thereof,
mhm,
but you own the copyright to the work,
mhm,
meaning the song,
mhm.
then you can do the folio registration.
Okay, great. Yeah, because I'm in a, I have several cycles that I have full permission. All I have to do is pay the royalty to the poets, and they're groovy.
Mhm.
And then there's one I that I'm writing right now. I'm gonna have to pay the that upfront fee, and I'll make sure that I haven't um, finished that contract yet. But that's something I feel like I have to make sure that's in the contract, that I can register that.
Well, my friend, if you ever need any assistance on the contracts, you know where to
Yes,
go to.
indeed I do.
Um, but, I know you know more about the business than most composers and most musicians. So
Mhm.
the fact that you're talking about the contract in the level of detail that you are, I suspect that for these you're probably doing okay by yourself,
Mhm.
and you don't necessarily need the assistance of a lawyer. I mean, I've written some blog posts on my website
Mhm.
about clearing um, text, for
Mhm.
example. Um, it is something that a composer can do without the assistance of a lawyer. But of course, uh, copyright lawyers like me are always happy to help
Mhm.
if a composer either wants to or finds themselves in a kind of sticky negotiation, which
Mhm.
happens from time to time. The living writers tend to be very easy to deal with.
Yeah.
When you're dealing with estates and when
Mhm.
you're dealing with corporate publishers,
Mhm.
that's the time when it may get a little bit tricky, and you may not necessarily want to engage a lawyer to do all the negotiations, but you may want to pay a lawyer a couple of shekels to look over something before you
Mhm.
sign on the dotted
Yeah.
line. But basically, if you're doing a clearance with a living writer, certainly if it's somebody that you know personally,
Mhm.
it's usually a fairly straightforward thing.
Yeah, that's been just like, hey, will you write me a letter that says X, Y, and Z? Like, here's the language. Copy and paste it into Word, sign
And
it, date
and
it.
and and there you go.
Yeah,
So
it's on
um,
paper. It's in a file.
now, one of the things, and I had a conversation a couple of years ago with a composer and performer who I won't name names, but it's somebody that I'm sure you know,
Mhm.
or at least know of.
Mhm.
And this is another common misconception. This person said, uh, when I was talking about publishing,
Mhm.
and this person said, well, I have my works registered in my ASCAP or BMI company.
Mhm.
It takes your pick.
Mhm.
I used to work for BMI, and when I was at Boozy, I served on the ASCAP Symphony and Concert Committee. I have friends at both places.
Mhm.
They're both very good organizations, and what I like to say to people when they ask me about ASCAP and BMI, it's like Hertz and Avis, it's like Ford and Chevy. They both
Mm-hmm.
do the same thing. They do it in slightly different ways.
Mm-hmm.
Is one better than the other? My answer to that is it all depends upon personal relationships and where you feel comfortable.
Mm-hmm. Yeah.
Because let's say, uh, take a category like film composers, and
Mm-hmm.
let's say in 2016, word on the street is that BMI is paying film composers better than ASCAP,
Mm-hmm.
for example. So a whole bunch of people sign up with BMI, or they switch their affiliations, which if you ever try to do, or if you know somebody who's tried to switch from A to B or from B to A, it's not the easiest thing in the world.
Yeah,
They
it
have
seems like it's complicated.
it is complicated because they have these licenses and effect
Mm-hmm.
provisions. And do you leave your existing works? Do you take everything with you?
Mm-hmm.
But going back to my example, so there's a run on BMI for film composers. They all join. It's a finite pot.
Mm-hmm.
So what that means is that BMI suddenly will have this about the same pot of royalties to distribute
Mm-hmm.
to film composers, but they're dividing it by more film composers.
Mm-hmm.
So then people start, and this migration back and forth happens over time, which is why I say over time. And you don't want to be changing performing rights organizations, like you change your clothes.
No.
Um, it's you should have it for a long-term relationship, and
Mm-hmm.
over time,
Mm-hmm.
A and B will pay about the same, and
Yeah.
it comes down to where you feel comfortable and where you have, good personal relationships, and where your friends
Mm-hmm.
are, and
Yeah.
that sort of thing. Again, there are some differences in how ASCAP and BMI operate,
Mm-hmm.
and again, you may decide you like one or the other. Uh, either way, uh, my point is any writer of music, regardless of genre, whether you consider yourself a new music composer,
Mm-hmm.
or you're writing bubblegum pop,
Mm-hmm.
or you're writing, library music or film cues or what have you,
Mm-hmm.
should always belong to a PRO.
Mm-hmm.
Getting back to what
Yes.
this composer who shall remain nameless said was, well, I have my works with ASCAP. That's all I need to do. Well,
Mm-hmm.
this is something that the PROs do say up front, but really don't quite get across to songwriters and composers. There are in section 106 what we call the bundle of rights for
Uh-huh.
copyrights.
Mm-hmm.
There is the right of public performance.
Mm-hmm.
There's the right of reproduction and the right of distribution. There's
Mm-hmm.
the right to create derivative works.
Mm-hmm.
There's a certain bundle of rights. Okay? ASCAP, BMI, and CSAC, now Global Rights Management, the new PRO founded by Irving Azoff, which is invite only, and if you're only a megastar songwriter.
Mm-hmm.
Um, but for the most part, we're talking ASCAP and
Mm-hmm.
BMI. Out of the bundle of rights, how many of them do you think the performing rights organizations represent?
One or two.
One.
One, yeah.
They only represent the right of public performance.
Mm-hmm.
So when a work is broadcast on radio, TV,
Mm-hmm.
when it's streamed over the internet, when it's performed live in any place,
Mm-hmm.
whether it's a concert hall, a stadium, a nightclub, what
Mm-hmm.
have you, any place it's publicly performed, the PROs are supposed to license those venues and collect royalties on behalf of songwriters, composers, and music publishers.
Mm-hmm.
But they don't handle mechanical rights, which are the royalties that songwriters and composers get when their works are embodied in sound recordings, meaning
Mm-hmm.
CDs and downloads and LPs.
Mm-hmm.
They don't handle synchronization rights,
Mm-hmm.
meaning the license that you need to include a piece of music into an audio-visual work, whether it's film, TV, advertising, or just something for the web.
Mm-hmm.
Um, they don't handle sheet music.
Mm-hmm.
So you need to do one of two things. Either you need to be enterprising like one Dennis Bensky and become a self a truly self-published composer,
Mm-hmm.
and people like you and one of my predecessors in your talks, Alex Shapiro,
Mm-hmm.
does this very well and does this very successfully. But as you know, and I'm sure as you discussed with Alex, it's a lot of work, and
Yes.
you have to know a lot about the business.
Mm-hmm.
And if you don't know a lot about the business, you need to learn about the business.
Mm-hmm.
Um, the other option,
Which
which
is why you're here. To
uh,
teach us.
among other reasons,
Yeah.
the other option, which is tried and true, is to affiliate with a music publisher.
Mm-hmm.
And the music publisher, uh, their job is to collect all of the income except for public performance, which is paid. As you know, there's a writer's share and a publisher's share.
Yes. Mm-hmm.
And if you are self-published, you collect both the writer's share and the publisher's share.
Mm-hmm.
But if you have a publisher, whatever the nature of that relationship is, whether it's a traditional copyright deal or it's an admin deal, and if you want, we can talk about that, but we haven't even begun to talk about fair use. Um,
Mm-hmm.
the publisher's job is to collect and try to exploit all those other income streams.
Yes.
So my composer friend was sadly mistaken by saying, well, I formed my little ASCAP publishing company and I'm
Mm-hmm.
registered with ASCAP. That's all I need to do. There's a lot, there
Yeah,
are
that's
several
one thing
other,
you need to do.
that's one thing you need to do. ASCAP, one of the differences between the way ASCAP and BMI operates is ASCAP, in order to collect the publisher's share, you actually have to have an ASCAP publishing company.
Yes.
And so, some people say, well, you need to form an LLC or a corporation or anything. If you're, unless you're operating at a certain level, and which most new music composers unfortunately are not,
Mm-hmm.
um, you're probably best off just forming a sole proprietorship,
Mm-hmm.
um, which you can just file a certificate in the local county clerk's office for a couple
Yeah.
of bucks. You don't need to form a corporation. You don't need to
Mm-hmm.
form an LLC. Um, you just fill out the paperwork for ASCAP or BMI. BMI, they will pay the publisher's share to the writer if they're not otherwise affiliated with a publisher.
Okay. Cool.
They'll pay what they call 200%.
Mm-hmm.
ASCAP operates on 100%, meaning
Mm-hmm.
50% is the writer's share, 50% is the publisher's share.
Mm-hmm.
BMI operates on 200%, meaning somebody gets paid 100% or a portion of 100% of the writer's share, and
Mm-hmm.
somebody gets paid the publisher's share.
Mm-hmm.
So if you don't have a publishing company at BMI, you can register 200%, and you
Nice.
will get paid all of your public performing royalties.
Nice. I had wondered how that worked. I'm an ASCAP guy. I know people who are with BMI, but I've never quite known how they do things
But
over there.
uh, form, you had to submit 3 names, fill out the application,
Mm-hmm.
pay the registration fee, the one-time fee to
Mm-hmm.
pay ASCAP to join as a publisher member.
Mm-hmm.
It's free to join as a writer for both ASCAP and BMI.
Okay. Cool.
Both of them charge to
Is
join
it?
as a publisher. Yeah, I don't think you pay a fee.
I I have to,
Again, they may have changed
I
that.
think it may be I think that it's like a $50 fee to
Yeah,
join as a writer because
they may have changed that. I haven't looked
yeah,
at that in a while. But in any event, if you do have to pay a fee, it's a one-time
one time
fee.
and
It's
you're done.
fairly nominal. Nominal. The publisher fee is a little bit more. I think it's somewhere in the neighborhood of $250.
Oh, is it?
Uh,
I got in super cheap then.
it, you know, it may still be less, but
Yeah.
but again, it's certainly under 500.
Yeah,
And
oh yeah. I'll actually while you talk I'll look
you
it up.
if you go to ascap.com, you can look it up real fast. But the point is,
$50 for either one.
it's a few dollars.
Yeah.
And again, with the caveat that I am not a tax attorney, I am
Mhm.
not an accountant,
Mhm.
but if you are pursuing music as a career,
Hmm.
whether it's full time or part time. All of these check with your tax advisor, but all
Hmm.
of these are deductible business expense.
Absolutely. Absolutely.
So, as are fees to consult an attorney.
Hmm.
Um, people, one of the things that I find frustrating as an attorney with music clients, and one of the reasons why I'm a sole practitioner is I like representing composers. That's
Hmm.
my background. I don't represent superstar megastars. So I try to keep my overhead and therefore my the fees that I charge low.
Hmm.
And even then, composers will not seek out counsel they'll where they will have spent well over $100,000 and
Hmm.
sometimes over $200,000 to obtain their bachelor's, master's, and sometimes a doctorate,
Yeah.
and spend tens of thousands of dollars on equipment.
Hmm.
So that's just a tiny little plug that, again, this is your career.
Hmm.
Seek out advice. Doesn't have to be from me. There are plenty of other competent
Hmm.
copyright lawyers that deal in music. Um, but anybody who is trying to make a go of this, whether full time or part time, should seek out competent advice.
And one of the reasons to do that is it's whatever you may pay for that advice, it will probably save you
Right.
so much more in the long run.
Exactly. That's what I always tell people. So do we want to talk about any other aspects of copyright law before we do a little thingy about fair use?
Yeah, I actually had a couple of things here that I wrote down that I wanted to make sure to touch on. So you're talking about registering with ASCAP and forming a sole proprietorship. That's kind of how I operate. Uh, I'm wondering. This is something that
See, you knew to do that, and you didn't even have to talk to me.
yeah, it's something that has come to me over the years. But one thing that has been on my mind lately, I'm thinking, and one of the things, and this is a thing that I want to have you back to talk about at some point. I'm thinking like past my death. I'm thinking hopefully I will live a very long and productive life, but I'm trying to think
Mhm.
that long, and I'm thinking sort of estate planning ish, because it better to do it early than late, or too late. So I'm thinking it, it might be advisable at some point for me to transfer my copyrights to a business entity. For the like, if I do an LLC, I would transfer all of my copyrights to live there to sort of, in case God forbid something happens and I have to declare bankruptcy, I don't lose those copyrights because you in a bankruptcy you can lose them, correct?
Yes, it is possible to lose property, and of course, copyright is a form of property.
Mm-hmm.
People can get liens on various assets,
Mm-hmm.
um, but you know,
Am I being
copyright.
overkill in thinking
Well,
about that?
no. In fact, I wrote a blog post last year
Mm-hmm.
about a couple of checklists to create to do if you're a writer and you write music.
Mm-hmm.
The post's on my website and it was actually picked up thanks to Alex, who you know posted it on her Facebook page, and then
Mm-hmm.
Dean Kay picked it up
Mm.
in uh, in
Oh yeah.
his daily blog, and it's the one time I've been in slip disc. Norman Lebrecht picked it up.
Nice.
So anyway, it's one of my most read blog posts for that reason.
Mm-hmm.
And there, I go through a couple of checklists. Um, Copyrights are considered personal property, like a car
Mm-hmm.
or your TV set,
Mm-hmm.
your computer. So you can leave that to whomever you want in a
Mm-hmm.
will.
Mm-hmm.
And again, you can leave ownership of the rights to one or more individuals.
Mm-hmm.
You can put it in a trust. You can
Mm-hmm.
have the ownership with one entity and have the royalties distributed to others. There
Mm-hmm.
are any number of ways to do that.
Mm-hmm.
And the first thing that I would suggest is, look at that blog post that I wrote, because
Yeah.
it'll just give you some ideas and will tell you what kind of information you need to collect
Mm-hmm.
to talk to whoever you use to plan your estate.
Mm-hmm.
And then you should talk to an estate lawyer who knows something about intellectual property and
Mm-hmm.
copyrights. And that individual, he or she, will advise you on the best way, given the particular facts and circumstances of
Mm-hmm.
your interest, as to how it would be best to deal with your copyrights uh, after your demise.
Mm-hmm.
Because after all, life is 100% fatal.
Exactly.
Um, so, one of the things that I mentioned in that post is, if you have a will, you're going to have an executor.
Mm-hmm.
But that executor, let's say, for most of your property, for your home, for your personal possessions, for your books, all that stuff, it could be a close relative or a family friend. However, that person may not know squat about
Mm-hmm.
music,
Mm-hmm.
may not know how to evaluate your music,
Mm-hmm.
and decide, okay, well, Dennis wrote this instrumental piece. Would somebody wants to add lyrics to it,
Mm-hmm.
or so, now Dennis has this publishing company and he ran it himself. You may want to consider having a separate, what in the publishing biz, a literary executor in
Mm-hmm.
addition to your overall executor,
Mm-hmm.
to deal specifically with the issues relating to your musical output. Somebody who can actually proof the score and say, "Oh, did Dennis really mean to put that A sharp in the horn part, or is that a typo?"
Mm-hmm.
Um, so, absolutely, one should think about estate planning issues, but I wouldn't say categorically you should form a corporation and put
Mm-hmm.
the copyrights into that corporation, because chances are it would be, an S corp or an LLC of which
Mm-hmm.
you are the sole shareholder,
Mm-hmm.
and then what?
Yeah.
So that's why, again, I have that post that lists all the stuff that you should have ready and some questions to think about, and then you talk to somebody who
Mm-hmm.
will do a statement for you.
Cool. Cool. Yeah, it's been something that I've been toying with in the back of my head for a little while, and it's hopefully knock on wood, it's too early to deal with that, but it.
It creates a lot of problems if you at least don't have a basic will.
Oh yeah.
Exhibit
Oh.
A, Prince,
Mm-hmm.
who was a control freak about
Mm-hmm.
everything, but apparently did not leave a will.
Mm-hmm.
And you don't have to be a fan of his music or anything, but it's all over the popular press and the internet,
Mm-hmm.
and all sorts of talking heads have been talking about the implications of the fact that he didn't leave a will. And it's like, who's in charge?
Yeah.
Nobody knows.
Yeah. Yeah. I heard. I was reading a couple of years ago. There are two authors I mentioned back when I talked with Alex in episode one. So when that goes out, you can hear that. Dean Wesley Smith and Christine Catherine Rush, who write a lot about publishing issues. Dean was like the executor of the estate of a friend who is not a writer, and he didn't really handle his affairs very well. He was a major collector. He had millions of dollars worth of comic books and rare editions of things in his home, in various storage facilities around the place. He lived in Washington, died in Nevada,
Mm-hmm.
and the whole thing. It, Dean was just, it actually made him go blind in one eye. It was so stressful dealing with this poorly handled uh, estate, that that started them talking about estate planning. It got me thinking about it a few years ago. It can be, and God, if he had intellectual properties to deal with, how much worse would that have been?
Exactly. So it's something that people generally don't think about, and if they do, they're thinking about their home and their
Mm-hmm.
kids and their surviving spouse, and they're not necessarily thinking about their creative output if they're
Mm-hmm.
composers or writers or painters or photographers or what have
Mm-hmm.
you. And that should be separately addressed. You don't want it just lumped in with
No.
all your personal property.
Yeah. Another well, I asked on Facebook to have people send in some questions, and we got one. Um, uh, a friend of mine, Martha, she wrote in. I just wanted to like talk about that briefly. Talk about what her situation was. She has written a song cycle. I thought she was going to write a song cycle, but it is written, and the author of the poetry is British, and the poems were written in 1916, but the poet died in 1960, and the estate had said, oh yes, this is still under copyright, and she thought, oh, I thought anything before 1923 was public domain. I'd like to kind of have you respond to that. I forwarded your response, but I think it's something important to
Well,
think about.
I figured I was going to address this in our conversation, which is why I just kind of gave a very, you know, shorthand
Mm-hmm.
response. So basically, the Copyright Act of 1976, which went into effect in the United States on January 1, 1978, was written with an eye towards the United States joining the Berne Convention, which
Mm-hmm.
most countries of the world have joined a time ago, including Great Britain.
Mm-hmm.
Um, under all prior copyright statutes, prior to the current Copyright Act,
Mm-hmm.
there was what we called an initial term and then a renewal term.
Mm-hmm.
And then under various provisions of the current Copyright Act, the old renewal term under the old act was extended
Mm-hmm.
a couple of times. Most recently under the Sonny Bono Copyright Act of
Mm-hmm.
1998, I think it was.
Something like that.
Um, so what happened was you had an initial term and you had a renewal term.
Mm-hmm.
And so, with all, let's fast forward to all the extensions, the most recent of which uh, uh, extended newer Copyright Act, meaning those under the new Copyright Act, January 1, 1978 and beyond, from life of the author plus 50 years
Mm-hmm.
to life of the author plus 70 years,
Mm-hmm.
which is the term of copyright for for just about all of the European Union and a lot of other places.
Mm-hmm.
For older copyrights, it was uh, the combined initial term and renewal term used to be 75 years.
Mm-hmm.
They added the other 20 years to that, so now it's a term of 95 years.
Mm-hmm.
So again, older copyrights in the United States were based from time of registration or publication, but it was
Mm-hmm.
a set period of years.
Mm-hmm.
The rest of the world, including Britain and now the United States, is on a life plus uh, X number of years,
Mm-hmm.
life of the author plus X number of years. What if there's two authors or three authors?
Mm-hmm.
The lifetime of the quote unquote author is the death of the last surviving author.
Yes.
Just to make that little point. So with your friend Martha's situation, while copyrights in the United States are public domain uh, for works 1923 or before,
Mm-hmm.
that doesn't mean that they're public domain in the rest of the world,
Mm-hmm.
and it doesn't mean that. Uh, so, with respect to this British author, chances are, even if, and it's possible, there are lots of works that are public domain in the United States
Mm-hmm.
that are still protected outside of the United States.
Mm-hmm.
Stravinsky's Rite of Spring, for example.
Mm-hmm.
Um, so it's possible, and I would need to do more research on it, that the works of this poet who died in 1960, whose works was published in 1916, it's possible that these works may be public domain in the United States, but it's almost certainly probable that they are still protected under copyright in the United Kingdom and maybe
Mm-hmm.
the rest of the world
Mm-hmm.
because of the difference between life of the author plus 50 or 70, what have you,
Mm-hmm.
and the old U.S. way of determining the duration of the copyright, which was, the initial term in the movie.
Mm-hmm.
So I hope that answers your friend's question.
Yeah, I forwarded that to her. She said, "Oh yeah," like I said, "Oh, I don't know if this means that you'll find some new text." She said, "I've already written it, so now I just have to hope that they're not gonna charge me an
Well,
arm and a leg to use it."
but one of the things that again, I had written a few years ago a blog post on clearing text, um, and the first thing I do, and I can name, it was before my time at Boozy, but I can name a well-known composer um, where the work was written prior to the text being cleared.
Mm-hmm.
And that certainly limits one's bargaining power when you already write the
I
piece.
know, yeah. And I
Um,
think we do. I think as we do that too much. We think, oh, either we don't think about it. We just say, I want to set it, or we say like, I'll deal with it later, and
oh,
then
you know
good
the
luck.
old phrase, you can pay me now, you can pay me later. If you pay
Mm,
me later, you're going to pay a lot more.
exactly.
So if you wait until after the work is already written,
Mm-hmm.
or God forbid it's a commissioned work,
Mm-hmm.
and there is payment by the commissioners and a premiere date and everything,
Mm-hmm.
then you're really in a horrible negotiating position
Oh God.
with respect to clearing the rights to the text.
Mm-hmm.
So clear the text
Mm-hmm.
before you write the piece.
Yeah, do it. You will. Yeah. It, you'll probably save a lot of money, and you'll save just so much time and maybe heartache that maybe you wrote the piece and now you can't use it. They don't
That's
want to go
exactly right.
negotiate at all, or
Yeah.
it's just too it's too much money that you can't afford it. Shall we move? I don't know if I want to even get into the the first sale thing, or if we just want to move on into fair use. That was something I had a conversation a while ago about that, and I know some people get a little about that idea.
Well, first sale, there the way to go by way of background is there is a distinction between ownership of a copy of a work, a
Mm-hmm.
physical copy, and ownership of the copyright itself.
Yes.
You've got a whole bunch of books behind you on your shelf. Are we looking at your home bookshelf?
Yes. This is actually my kitchen, but the one wall is for bookcases.
So Dennis, you let's assume that you legally purchased all of those books either at
Mm-hmm.
a brick and mortar bookstore through Amazon or what
Mm-hmm.
have you. So you own that copy of the book.
Yes.
You do not own the copyright. So
No.
you can't make additional copies of that book and either sell them or even give them out to your friends
Mm-hmm.
because, again, bundle of rights. The
Yep.
reproduction and distribution are separate rights
Mm-hmm.
for the copyright holder. Nor can you take your copy of the book and write an opera based upon
Mm-hmm.
whatever book is on the shelf, because
Mm-hmm.
that's the right to create derivative works,
Yes.
which belongs to the copyright owner. Where you
Mm-hmm.
get in a lot of trouble, or people get in a lot of trouble in music, is like, well, I bought the CD,
Mm-hmm.
so it's okay for me to put it in my video.
Nope.
Uh, no, you bought a copy
Copy.
of a CD
Mm-hmm.
to use as a CD. What
Mm-hmm.
the first sale doctrine says is when a work is lawfully purchased,
Mm-hmm.
okay, not stolen or anything,
Mm-hmm.
you can take that book and you can give it away, you can resell it, you
Mm-hmm.
can burn it if you want.
Mm-hmm.
What the first sale doctrine says, once there's a valid first sale, you can do what you want with that copy
Mm-hmm.
without needing any further permission of the copywriter.
Mm-hmm.
So first sale deals with sales of copies. It doesn't deal with underlying rights in
Mm-hmm.
the work. So
Mm-hmm.
again, the distinction between the ownership of the copyrights
Mm-hmm.
and the ownership of a physical copy of a work.
Mm-hmm. I had a conversation a few years ago. I stopped into ASCAP, and a few times I stopped in and talked with Fran Richard, and she was
Oh,
telling.
isn't she great?
I love her. She was telling a story. We were clearly talking about publishing stuff, and she was saying that there was a composer that she knew who I think he had written. It was like choral music that we were talking about. That such and such choir bought 40 copies for their
Mhm.
choir and then rented it to another choir for them to use, and the composer was bent out of shape about it. But she said, "But that's, that is, they bought it. They can do, it's not, they didn't make copies. They didn't do, there's nothing illegal that they did. They just rented their copies to another group for a limited time. You don't get that money. You don't
That's
get a cut
cor-
of that."
that's correct. Which is why certain works, as you know, are by industry custom. There's nothing in the law that says it has to be done this way, but by
Mm-hmm.
industry custom, smaller works, solo piano works, chamber works,
Mm-hmm.
choral works, are concert band works are done on a sale basis.
Yes.
Orchestral works, opera works,
Mm-hmm.
and why even chamber orchestra works,
Mm-hmm.
but not concert band.
Yeah.
So it's not necessarily the number of uh, pieces in the performance materials because concert band's pretty big,
Mm-hmm.
but certain works are done on a sale basis
Mm-hmm.
and certain other works are done on a rental basis.
Mm-hmm.
And as a composer or a publisher, you always make more money on a rental basis.
Absolutely.
So if you can write larger scale works, of course, you'll get more money, but the performance opportunities for, say,
Mm-hmm.
orchestral pieces and operas and musicals are much less than, say, solo piano works
Mm-hmm.
or SATB choir.
Mm-hmm. Yeah, with a band work, you're more likely to get more of those sales and get more of those performances. So yeah, fine, sell it to them,
Right.
and yeah, they may rent it to somebody else, but you get that performance royalty, which is great. But overall, you probably will make make a substantially more money for that type of work than maybe for an orchestral thing.
Right, because you're going to get more purchases, more performances.
Mm-hmm.
So anyway, yeah, that's an interesting example of first sale. Yeah, that there really not much you can do about that because
Yeah, there was something I thought it was interesting that she brought that up, and so it's always kind of in the back of my brain when I think about licensing your copyrights and dealing with intellectual property. That, yeah, if you sell those copies, if you sell it rather than rent it, just know that someone else can borrow it or
right.
someone else
Well,
can sell,
and that is
rent it.
why software companies like Microsoft,
Mm-hmm.
uh, you don't ever, you technically you don't ever purchase the
Mm-hmm.
software. You are licensing
Yes.
now. So when you license something, there is no sale, so the first sale doctrine doesn't apply.
Mm-hmm.
Um, and but on the positive side, what the software companies do is say, by the fact that it's a license, we have a continuing legal relationship,
Mm-hmm.
and that's why the license agreement says you agree that we can provide you with free updates to the software
Mm-hmm.
that you quote unquote purchase but are really licensing.
Yeah.
Um, there is no legal reason why people couldn't, say, license copies of their music instead of
Mm-hmm.
selling them,
Mm-hmm.
except for the fact that the market has been a sale market for
Mm-hmm.
you know couple hundred years now, and
Mm-hmm.
if a composer or a music publisher started saying, well, we're only going to license the work to you, we're not going to sell you the copy, there'd
Mm-hmm.
probably be a lot of brushback.
Mm-hmm.
Query, as we're moving into more and more of the digital realm, and
Mm-hmm.
a lot of performers basically just have PDFs
Mm-hmm.
on their laptop or pad and don't have, you know, physical paper anymore.
Mm-hmm.
Um, you know, we're probably, I predict, somewhere down the road, sometime in our lifetime, going to be moving to a digital licensing model, just like you have with ebooks.
Mm-hmm.
You cancel your Amazon subscription,
Mm-hmm.
right?
Yep. Yep.
Right?
Yeah,
So,
I with my digital works, I actually say that this is a copying license, and you have, this gives you the right to copy works for you and your ensemble, um, only, you know, just to sort of say like that. Look, if you just bought 40,
mhm.
a license to make 40 copies of this choral work, you can only make 40 copies, and also, like, I would prefer that you didn't share that because you got it cheap and someone else can get it just, I mean, it's super cheap to buy from me. So I do say that with digital works. Anything else, I'm like, yeah, you bought it, fine,
Right,
whatever.
exactly. So, um, I think we've already killed an hour, and we haven't even said
Yeah,
a word about fair use.
yeah. Do you want to go on and do that, or do you want to come back and do it another time?
Well,
It's a
well, look, it's I have a bit more time to sit and chat with you, Dennis.
cool.
Um, but what I, you know, the listener also, what I have experienced as both a lecturer and as a teacher
Mm-hmm.
of full semester courses is, after a certain point, you reach the law of diminishing returns,
Yeah.
and people's attention span only go on for so long.
Exactly.
So I'll leave it to you whether you want to have, an hour and change podcast that people know that they, or
Mm-hmm.
we can just go on and talk a little bit about fair use. I'm happy to come back and chat with you again.
Yeah, I definitely want you back several times.
It's been fun. Um, so so this is your show. I'm merely a guest.
Do you want to take another? Is 10-15 minutes good? Do you think we'll get enough done?
We'll certainly be able to cover the basics
Yeah, yeah. Let's at least do
in,
that.
in a few minutes. So let me give you the nickel version about fair use, because there's a lot of misconceptions about fair
Mm-hmm.
use.
A
Just
ton.
just as the copyright law generally is statutory based,
Mm-hmm.
subject to judicial interpretations of the statute, just as the Supreme Court, interprets the Constitution.
Mm-hmm.
The after all these years since the the Constitution was written in 1787. Just looking at the words on the page doesn't necessarily end the inquiry, and usually it requires uh, going through various judicial opinions
Mm-hmm.
interpreting those words on the page. Same thing with the copyright law. Fair use is codified in Section 107 of
Mm-hmm.
Copyright Act, and there um, is a non-exclusive list of things that are examples of fair use, like reporting and
Mm-hmm.
commentary and criticism and that
Mm-hmm.
sort of thing. Um, and there are four statutory factors
Mm-hmm.
that are included in Section 107. Um, and these are the purpose and character of the use, whether it's commercial or nonprofit or educational, the nature of the copyrighted work, which nobody knows what that means, including the judges,
Mm-hmm.
the amount and substantiality of the portion used in relation to the copyrighted work. So
Mm-hmm.
did you take the entire song? Did you just take the introduction? Did you take the main hook? So
Mm-hmm.
how much and what substantiality did you take?
Mm-hmm.
And the last factor is the effect upon the potential market or value of the copyright work.
Mm-hmm.
So those are your four statutory factors. There is, however, a judicial gloss on top of that, um, which has been in effect for over 20 years and was essentially adopted by the Supreme Court in the famous Two Live Crew case, Campbell v. Acuff Rose,
Mm-hmm.
involving Roy Orbison's song "Oh Pretty Woman."
Mm-hmm.
And Two Live Crew did their own version of Pretty Woman, which you can go on uh, go online and find it. You can get it for free on YouTube,
Mm-hmm.
along with the Roy Orbison version. And it's well, it's rap, so it's pretty explicit, shall we say?
Mm-hmm.
Um, and the band initially sought permission from the publisher, Acuff Rose,
Mm-hmm.
and not surprisingly, Acuff Rose said no.
Mm-hmm.
Uh, Two Live Crew decided to go ahead and do it anyway, claiming fair use, went
Mm-hmm.
all the way up to the Supreme Court. It was the first case that was decided by the Supreme Court that held that parody could be a form of fair use because parody is a form of commentary and criticism.
Mm-hmm.
And what the Supreme Court said in that case was, well, they only took a little bit of the song and then they went and did their own thing.
Mm-hmm.
So most of the song isn't just the melody and chord progression of "Oh Pretty Woman."
Mm-hmm.
You hear the classic riff, and
Mm-hmm.
you hear a little bit of the song, and then the rest of the song is all Two Live Crews.
Mm-hmm.
Um, and they said that this work did comment on the underlying work, um, and it doesn't have to be successful. The courts are not going to judge artistic merit, just whether you know there was some underlying commentary. So that that uh, case adopted this concept called transformative use,
Mm-hmm.
and I've written a few posts on this. In fact, this fall, I'm going to have an article published in the Copyright and New Media Law Journal, which
Nice.
is a journal about copyright, basically for non-lawyers. A lot of
Mm-hmm.
librarians, a lot of individual creators,
Nice.
other academics, uh, discussing transformative use because it's this kind of elusive concept. And so, what is transformative use, and why has it basically taken over uh, the the four-factor test? Because if you read any fair use decision since the Two Live Crew decision came out in the early 90s,
Mm-hmm.
they'll walk through the four factors, but they'll largely determine whether it's fair use or not, whether the use is transformative.
Mm-hmm.
So, what is transformative use,
Mm-hmm.
might you ask? Well, that's a very complicated question to which I still don't have a definitive answer.
Mm-hmm.
Um, but what I have suggested in this article that's going to be coming out later this year is, does the work comment on the underlying work
Mm-hmm.
in the nature of traditional fair use, commentary, criticism?
Mm-hmm.
Um, and if it doesn't comment on the work, does it at least provide some social commentary generally
Mm-hmm.
by using that work? And again, and finally, we had this decision, we had a couple of decisions very early on after Campbell,
Mm-hmm.
uh, back when search engines were first becoming popular. You had this
Mm-hmm.
case from the Ninth Circuit in California, Kelly v. Aribasoft, which every time you do a search, you have the thumbnails, right?
Mm-hmm.
So somebody sued saying, you're reproducing my work. And so the court said that the thumbnail was a transformative use because it's not a substitute for the work itself.
Yeah.
It is a use that is providing information about the work.
Mm-hmm.
And that is the basis on which the recent Google Books decision was
Mm.
decided, finding that the wholesale scanning of entire books and indexing them, and when you call up a work, it only
Mhm.
shows certain excerpts.
Mhm.
It's not a substitute for the work itself. It's providing information about
Hmm.
the work. Where you
Interesting.
get into some level of difficulty is, well, there's this concept called derivative works, and
Mhm.
derivative works are defined in Section 101 definitions in the Copyright Act. And you can go look that up at copyright.gov unless you would like me to read definitions to you. But to a layperson and even to the courts, um, there can be this overlap between what could be transformative and what is a derivative work.
Mhm.
Because the language of transformative, it recasts the work in a new way. Well, if you
Mhm.
take a piece that's originally for orchestra and arrange it for concert band, that's recasting the work. It's a new usage.
Mhm.
But arrangements are one of the things that are specifically listed in the Section 101 definition of a derivative work.
Mhm.
So, you know, is it fair use? Again, you have to talk about how much of the work you're using.
Mhm.
So, I've done a couple of blog posts for New Music Box, which you may or may not have read, and I had,
Mhm.
a couple of quizzes there. Um, you know, there's a lot of misconceptions about fair use. First of all, there's no such thing technically as fair use rights. People
Mhm.
talk about fair use rights. Fair use is a defense to infringement.
Yes.
That's what it says in the statute, and that's what the Supreme Court of the United States has said.
Mhm.
And so every appellate court, with the exception recently of the Ninth Circuit in the Lens case, the Prince Dancing Baby video case,
Mhm.
um, that said, with respect to notice and takedown, the DMCA, before you send a takedown notice, you have to consider whether it's fair use.
Mhm.
Well, that to me and to a lot of commentators is wrong, just plain out wrong,
Mhm.
because fair use is a defense. It's up to the person receiving the takedown notice to say,
Mhm.
no, it's fair use. It's
Yeah.
not up to me, the copyright owner, to make that evaluation.
Mhm.
So, in every place except possibly the Ninth Circuit, and even the Ninth Circuit only with respect to notice and takedown,
Mhm.
like sending a takedown notice to YouTube. Um, Fair use is a defense.
Hmm.
Second of all, even there is a specific statute, there are no hard and fast rules to determine fair use.
Mhm.
It's
Yeah.
always done on a case by case basis,
Mhm.
and to a certain extent, the trier of fact, whether it's a judge or a jury, it's the I know it when I see it test. Um,
Yeah.
um, so so with that in mind, there are certain things that people think are automatic fair use. Like if I only quote 4 bars of a song,
Yeah.
it's fair use. Or if I
Mhm.
only put up 30 seconds
Mhm.
of a recording or a video
Yeah.
on the internet, it's automatically fair use.
Yeah. Less than 10% of something.
But less than 10, yeah, that's another good one. Um, do a lot of these uses qualify as fair use? Sure.
Mhm.
Are these automatic fair use examples? No, because let's say you put up the 4 bars and it's the hook to a pop.
Mhm.
Chances are that's not going to be, if you incorporate that hook into your work,
Mhm.
that's not going to be fair use. After all, we have sampling,
Mhm.
and people have to pay to clear samples.
Mhm.
So, again, so there's no 10-second rule, 10% rule.
Mhm.
It's always done on a case by case basis.
Mhm.
The other thing about fair use is, why do so many people then get, quote unquote, get away with technically infringing?
Mhm.
The answer is what we call prosecutorial discretion.
Mhm.
Um, you, Dennis, as copyright owner, may see something up there that you may think is a technical violation, or if we're actually litigated, could be considered fair use,
Mhm.
but it's not worth it. Oh, kitty,
Yeah.
kitty!
This is Midget.
Hello,
He
midget.
he decided to come say hello, which is a little rare at this time of the day.
Yeah, I have a cat, Angel, who's very shy and skittish, so
Yeah, he's
he's
totally
probably not
skittish.
going to make an appearance.
I'm amazed he did.
Um, so anyway, just because something could be technically infringing, you may decide, okay, I'm happy with the usage, or I'm happy with somebody giving me promotional value,
Hmm.
but it should be the copyright owner's right to say,
Yeah.
okay,
Yeah.
uh, I'm going to allow this or not, unless it really is determined to be fair use.
Hmm.
So that's kind of the nickel version of fair use, and I think what we probably should do is in a subsequent visit go
Yes.
through some concrete and more
Yeah.
specific
Yeah. I want to
examples.
dive into this. I know there was a huge like to do a couple of months ago on the ACDA uh, forums and those message boards about fair use, and I want to talk about that, but we can do that another time
Yeah,
because yeah, we're over an hour.
I'm not familiar with that brouhaha.
Oh, I'll tell you about it
Yeah,
briefly afterward, and
yeah.
we can jump
Tell
into
me
it.
about it, and before our next visit,
Yeah,
if you
I'll
send,
see you probably Sunday, right? Are you at the concert?
yeah, I'll probably be there.
Awesome.
But in any event, before we talk again, if there's actually some links to some of these
Yeah,
discussions,
I'll point you to that stuff.
yeah. So
Cool.
cool. So anything in conclusion for this particular session?
I one thing that I meant to ask earlier, and I want to make sure that we get this out there.
Yes,
Where can people
no.
find you on the web?
Well, if you Google Marc Ostrow, Marcostrow, there are actually a couple of Marc Ostrows out there, including another lawyer who actually, and there's another guy who's like a software engineer. That's definitely not me. uh, Spells the name the same way, Marcostrow. So you can certainly find my website that way,
Hmm.
or you can go straight to my URL, which is OstrowesQ.com.
Hmm.
And I have over 70 blog posts on my
Nice.
site and other useful information because I like to help uh, composers and songwriters and
Hmm.
other artists who generally have more time than money. I have
Hmm.
this thing called the Artist Legal Tune Up, where for a modest flat fee, which is much lower than my typical hourly rate,
Hmm.
you can either do a phone or Skype session with me for either 30 minutes or a half hour and just get some basic advice, uh, or I will review a contract or give you some basic information,
Nice.
and it's very very easy, um, and compared to what you would pay for other legal services, pretty darn cheap.
Nice. Nice. One thing I'm gonna hold this up. Have you ever heard of? You've probably heard of this, the Copyright Handbook from Nolo.
I'm certainly familiar with Nolo, and their stuff is generally pretty good.
Yeah, a bunch of writers that I follow, they're like that. You should have that. You should, that can get you more detail than we can go
Well,
into.
the books that I recommend specifically
Yeah.
for musicians
Mm-hmm.
and composers, because again, I teach music business classes
Mm-hmm.
at Rider, are Don Passman's All You Need to Know About the Music Business. And I'm just going to my shelf to see what edition the current edition is. Um, it's the ninth edition. And the other book that I used this semester, which is very good, is Steve Gordon's The Future of the Music Business, fourth edition.
Okay, cool.
Um, Both of these books are very good. Nolo also has a book specifically on music law.
Yeah.
Um, so
Yeah, I'm going to
those
link to
are
these in the show notes. So if people go to the website, they can see. I'll link to you too, so that they can see all of the stuff that you've written.
right. So yeah, any event, you know, here's Passman, here's Gordon. Um, so yeah, the Passman and Gordon book. Passman has been around for a long, long time, and it's probably the most well-known trade press book about the music business.
Nice.
It it has stuff about copyright and music publishing,
Mm-hmm.
which is what's really key for songwriters and composers. But it's mostly about the recording industry and
Mm.
touring and merchandise, which is of less importance
Mm-hmm.
to composers and songwriters, unless they also happen to be performers and recording artists.
Mm-hmm. Mm-hmm.
Um, so the Gordon book has more stuff about the digital world than Passman, which is one
Mm.
reason why I recommend that.
Nice.
And like I said, I've got a lot of stuff on music and copyright, including
Mm-hmm.
fair use on my website.
Awesome. I'll make a point of linking to that. So yeah, let stick around here for a second after I stop the broadcast. But thank you so much for doing this. This is
Oh, you're
great, and
very
I
welcome. It's been a pleasure, and I look forward to doing another session with you.
yeah, me too. That's good. Sweet. Well, thank you very much, and I'm gonna stop this here, and I'll talk to you in a second.